just now, about 5 years.
No, they organized many. I've been thrice to talk to High Court judges at the National Judicial Academy on RTI.
Okay.
Yeah. It's not exclusively on RTI. They have these things where they have a session, 2-hour session on RTI. And I've been there 3 times so far.
The only thing is we'll do it slightly different in the sense that whenever we do the Judicial Colloquium, we bring the activists. Now it might surprise you, even when the we did one on the right to education, where 10 Supreme Court judges and about 40 High Court judges from all across the country came. And the activists came there in that meeting. I mean, we choose them carefully, knowledgeable persons, and they spoke very strongly against the Right to Education Act, which was enacted. And the judges were very receptive. So they liked the combination of statutory bodies. So you'll be on it, the commissioners will be on it, maybe 5, 6, 7, 8, 9, say 10 commissioners. But there'll also be activists and judges. So it's a different kind of judicial colloquium where the judges get a feeling of what the demands and the aspirations of the activists are. They like that. So in the Bhopal Academy, we'll ask them to sort of change their normal style and do it in the way in which we want to do. I want to negotiate that with them. That we can do. So that judicial colloquium is the second thing on the agenda. The third, of course, is we're getting a feeling that many of the right to information activists are very good when it comes to the Right to Information Act. But how do you use the writ jurisdiction to enforce some of the provisions of this act? That is actually not very well developed. And that is because lawyers remain very unknowledgeable, if you like, about the provisions of the act. The activists are very knowledgeable, but how to use writ is not known to them. So maybe we are thinking of I was talking to Arvind in the afternoon break. We're thinking of a situation where activists and lawyers and commissioners think of innovative ways of going to the High Court and getting orders. Now, proactive disclosure, again, the High Court avenue is clearly available. You have to go carefully and do it, but clearly available. So even if the Information Act gives you some kind of impediment or you find it difficult to pass orders and get implementation, the High Court in writ jurisdiction is actually a clear alternative as well. Then we are coming out with all kinds of publications. I think we'll do one on the leading judgments of the High Court, Supreme Courts and Commissioners of this. We'll do that, again, a collaborative attempt so that people have a nice volume in their hands, and updated volume every year of the leading judgments. The disability organizations with the NHRC have published a handbook. So the disability commissioners together with the NHRC published a handbook of all the relevant documents for disability reservation and so on. So all the DOPT circulars are all in that and analyzed, and so NHRC did that work. So it's possible that we draw NHRC also into a project like this on right to information. Maybe the book can be published with us and the NHRC jointly. And so. But I want to thank all my colleagues. I mean, just to my other friends. That's very nicely done, sir.
Fantastic.
Yes.
I was telling Mr. Andy that it's
very nicely done.
These young people who have done it.
That's it.
It's a great work.
Yes, sir. I mean, it's an initial attempt. With all our mistakes and so on, it's an initial attempt.
This kind of meeting, if it will be in regular interval, it will be more helpful because sharing idea and knowledge, I think, is a very good thing. Then last, I think you had a meeting in Pune, 2006, I think. No?
You were there, sir?
No, I was not there.
2007.
2007. Then I think it's long gap, but I have gone through that minutes. So really that help, guiding us even in our decision. So if such minutes and such papers are made available, even if the commissioners or new commissioners who it becomes, it is very, very helpful. I think more of this type of organization is possible, then it is very good. And we have in the convention, information commissioners convention, there is a huge lot of things and we can discuss even a single thing in the properly, so it does not serve much purpose. So I think this kind of thorough discussion is very useful. Thank you.
Yeah, Mr. Sekhar Singh, please.
Well, I think I just make 2 or 3 points and then we should probably wind up. But first of all, I just want to share with you, and this is, you were sweet enough to talk about what you saw as a success in this. I want to put it from our side that, as I mentioned earlier, I've attended 3 meetings with High Court judges, with Supreme Court judges being present there to discuss RTI. And it was the most unpleasant experience of my life because they're all pompous, they think they know it all. They pass judgments on RTI without even knowing about the RTI Act, etc., etc. And I must say that, and that's why I look forward to your colloquium, because I think a lot of work has to be done with many of these High Court. I mean, there are of course exceptions, but with many of these judges, because I don't think they really bother to understand it. Now, in that way, the interaction with the information commissioners has always been just the opposite. And it's been a wonderful, this is not the only one in Pune, and there have been other interactions. And I feel that that is something, as they say that however good or bad a person is, the tone of an organization improves that particular person. I think there has been an interactive and open tone to information commissions, not just the Central Commission but across, which have had. There have been a lot of disagreements. There are many things that we still disagree with, we think should have been done, etc. But they're all done in a very pleasant atmosphere. I must say on the first day when people were being introduced and I found that there were so many people from outside the system, I was a little nervous. But you have picked them very well. I think it was an extremely responsible audience, which raised all the issues that needed to be raised, but in a manner such that they were constructively raised. Now, let's just link up briefly to what our expectations were if you remember, in the first day, the first morning. The first expectation was that we would all sit together and be able to discuss issues, especially for the benefit of those information commissioners, of which there were a few who were relatively new to the system, and so there is a passing on of this thing. And I feel that the sorts of discussions that have taken place should certainly make everyone think further on each of these issues. We might not always agree how to interpret 7.9 or how to interpret 8.1J or whatever, but at least it takes that debate to the next level, which I think is very important. I would here mention that Colin and I used to often discuss this in the run-up to this, of how many would be an ideal number of information commissioners attending. I feel that if we had had the initial anticipated 25 or 30, it would have been very difficult to have had this sort of an informed interaction, because this is the problem with the CIC's meeting, I feel. There are too many people, too little time. So I think it is much better to have 10 or 15 people and enough time for them to be able. I don't think anybody has the sense today that they didn't get an opportunity to say or discuss things that. And this is especially true with RTI, because as I often say, RTI discussions are like antibiotics. Either don't take them or have a full course of the discussion, because if you leave it halfway, people go away reinforced in court rather than to high courts, because the trouble with the high court is that their jurisdiction usually gets restricted to just that particular state, so you have to go from state to state to state. He had suggested, Arvind, you were not there, but he had suggested, for example, that this current case which is going on, which is, if you remember, the appeal against the High Court order.
Subhas Agrawal case.
Sorry?
Subhas Agrawal case.
Yeah. We could, some of the NGOs could become interveners in that case. And also take up issues like, for example, the inappropriateness of the rules formulated by some high courts. This was his suggestion, and I think we need to look at it very closely. And I feel that now this is only the lawyers can advise us which is the right time to do it, but I think we need to try and get some of these things sorted out at the Supreme Court level so that they become universally applicable. So I think that was one of the lessons that I took away from that particular thing. The next session dealt with the exemptions under Section 8, and we had detailed discussions on that. The interesting thing was that barring one point, there didn't seem to be a disagreement across the table. And even that one point I think became so complicated in the sense that it was really the point about how much, whether you can hold people responsible beyond a point. In fact, Shailesh and I also disagreed on this, that whether we can actually hold PIOs responsible beyond a certain point for what is happening in the public authority, etc., etc. But I think broadly speaking, it was a very positive sort of thing, and I would, taking up the point that the Information Commissioner from Arunachal made, I would strongly recommend that, Colin, if you could send out detailed minutes of the meeting, it might be very useful to even those commissioners who did not come for this meeting. Then the other thing was that we also discussed the other forms of denial apart from Section 8. And unfortunately, we did not get yesterday that table which would show us how many of these were, which didn't come. But I'm hoping that you could then circulate it later on to all the participants so that people get some statistics about how often provisions which are not strictly within the law are being used by commissions across the country to reject applications or deny. I think it's very important because that then sets up the flag in the mind of Information Commissioner that I must be careful. I remember, I won't mention names, my informally talking to one Information Commissioner and saying to him, a Chief Information Commissioner, that look, we've been looking at your orders and you seem to be using this particular section in a way in which I'm not sure if it is appropriate. And a 5-minute discussion made him think, and he said, okay, I think I understand now. And then later on we checked and he had actually changed the way in which he was using that. So what I'm saying is that there is a fair amount of open-mindedness among commissioners who, if they are rationally and reasonably pointed out some of these things, and so I think we need to circulate these things to them. Then of course there was the whole order about the continuing mandamus and the arrest warrants, where we particularly missed you, Arvind, because this is your favorite thing. And I think the points that came across very strongly, one was the plea, and I think Shailesh made this very strongly, that continuing mandamus is alright for those commissions where you're dealing with 10 or 15 or 20 cases. But he made out a balance between how quickly you dispose of cases and whether you can continue to have continuing mandamus. Now, to this point, let me also mention, link back to something that Justice Shah had said in the morning. Because he had given a view that once you've given a final order, legally you cannot reopen that case. So he had also said that, look, if you want to take any further action, you've got to adopt some sort of a continuing mandamus system. Mr. K.K. Mishra today pointed out that at least the Karnataka High Court has come up with some very progressive orders which could then be used for this. So I think we need to gather this together and build up a sort of an approach, because he might be right that maybe in 4 or